New Jersey Real Estate Exam Final Review. Question 1. Before meeting a client in Princeton, a person wants to qualify for a New Jersey real estate salesperson license. Which requirement must the applicant meet before licensure? Option A. Complete 150 hours of broker education and open an independent office. Option B. Take only a continuing education course after receiving a license. Option C. Complete the 75-hour pre-licensure course, pass the exam, and apply through a sponsoring broker. Option D. Pass the exam first and then decide later whether to affiliate with any broker. The correct answer is option C. Complete the 75-hour pre-licensure course, pass the exam, and apply through a sponsoring broker. A New Jersey salesperson applicant must satisfy education, examination, sponsorship, and character-related licensing requirements before practicing. Choice A is wrong because that applies to broker-level preparation, not the basic salesperson license. Choice B is wrong because continuing education is for renewal, not initial salesperson qualification. And choice D is wrong because a salesperson license is issued through an employing or sponsoring broker. Question 2. During a transaction in Atlantic City, an experienced salesperson asks what is required to become a New Jersey broker. Which combination best matches the broker eligibility path? Option A. A high school diploma only, if the applicant passes the state exam. Option B. A referral license and 6 months of office work. Option C. 3 years of full-time salesperson experience plus 150 hours of approved broker education. Option D. 1 year of part-time sales experience and a 75-hour course. The correct answer is option C. 3 years of full-time salesperson experience plus 150 hours of approved broker education. Broker candidates are held to a higher standard because they may supervise brokerage activity and handle office responsibilities. Choice A is wrong because education and approved experience are still required. Choice B is wrong because referral activity and office support do not replace the broker prerequisites. And choice D is wrong because that resembles entry-level salesperson preparation and does not satisfy broker experience requirements. Question 3. In a brokerage file review, a salesperson completes the pre-licensure course and receives examination eligibility. How long does that eligibility generally remain active? Option A. 30 days after the school certificate is issued. Option B. 2 years after the course completion date. Option C. Indefinitely as long as the candidate keeps studying. Option D. 1 year from the date it is issued. The correct answer is option D. 1 year from the date it is issued. New Jersey candidates must pass the examination and complete the licensing process within the applicable eligibility period. Choice A is wrong because that is too short for the standard eligibility period. Choice B is wrong because that overstates the eligibility window. And choice C is wrong because eligibility expires and does not remain open forever. Question 4. For a duplex in Edison, a public complaint alleges that a licensee violated real estate licensing law. Which body has regulatory authority over New Jersey real estate licensees? Option A. The New Jersey Real Estate Commission. Option B. The County Tax Assessor. Option C. The Multiple Listing Service only. Option D. The Local Board of Education. The correct answer is option A. The New Jersey Real Estate Commission. The New Jersey Real Estate Commission administers and enforces the state licensing law and related professional standards. Choice B is wrong because tax assessment duties are separate from license discipline. Choice C is wrong because an MLS may set membership rules but does not issue state licenses. And choice D is wrong because that agency does not regulate brokerage licenses. Question 5. While preparing a listing package, an applicant has completed education and passed the exam but has a serious character issue on the application. Which principle controls the licensing decision? Option A. Character matters only after the first renewal. Option B. Passing the exam automatically guarantees a license. Option C. The commission must be satisfied with the applicant's honesty, trustworthiness, character, and integrity. Option D. Only the sponsoring broker decides whether the state issues the license. The correct answer is option C. The commission must be satisfied with the applicant's honesty, trustworthiness, character, and integrity. Real estate licensing protects the public, so New Jersey considers more than classroom completion and test performance. Choice A is wrong because character qualifications apply at initial licensure. Choice B is wrong because examination success does not eliminate character review. And choice D is wrong because broker sponsorship is important but the commission makes licensing determinations. Question 6. At a salesperson training session, a new salesperson passes the exam and wants to start showing property immediately as an independent agent. Which action is required first? Option A. The candidate may collect commissions directly from clients before sponsorship. Option B. The candidate may practice alone for 90 days after passing. Option C. The candidate can use a friend's broker license temporarily. Option D. The candidate must complete licensure through an employing broker before practicing. The correct answer is option D. The candidate must complete licensure through an employing broker before practicing. A salesperson operates under a broker and cannot lawfully act independently before the licensing process is completed. Choice A is wrong because compensation must flow through the proper brokerage relationship. Choice B is wrong because passing the exam is not the same as holding an active license. And choice C is wrong because licenses are personal and cannot be borrowed. Question 7. After receiving an offer in Newark, a broker candidate wants to schedule the broker examination before state approval of experience. What should the candidate understand? Option A. The candidate only needs a salesperson pocket card at the test center. Option B. The candidate should wait for the certificate of examination eligibility before making the reservation. Option C. The candidate may schedule first and submit experience later. Option D. The candidate may skip the certificate if the employing broker signs a letter. The correct answer is option B. The candidate should wait for the certificate of examination eligibility before making the reservation. Broker examination eligibility is controlled by the Commission's review of education and experience. Choice A is wrong because broker candidates need the required eligibility documentation. Choice C is wrong because broker candidates must be approved before making the broker exam reservation. And choice D is wrong because a broker's letter does not replace the state eligibility certificate. Question 8. During an agency disclosure conversation, a salesperson receives a referral fee offered directly from a mortgage lender for sending a buyer. How should the salesperson respond? Option A. Ask the lender to label the payment as a gift. Option B. Accept the payment personally if the buyer consents. Option C. Deposit the fee into a personal account and disclose it later. Option D. Refuse direct compensation and follow compensation rules through the employing broker. The correct answer is option D. Refuse direct compensation and follow compensation rules through the employing broker. A salesperson's real estate compensation must be handled through the supervising broker and cannot be taken directly from outside parties. Choice A is wrong because renaming compensation does not cure an improper payment. Choice B is wrong because buyer consent does not authorize compensation outside the broker relationship. And choice C is wrong because personal receipt of unauthorized compensation violates compensation rules. Question 9. In a compliance audit, a broker is reviewing supervision duties for affiliated salespersons. Which statement best describes the broker's responsibility? Option A. Salespersons supervise themselves once licensed. Option B. The broker must supervise licensed activity performed through the brokerage. Option C. Supervision applies only to commercial deals. Option D. Only the office manager is responsible for legal compliance. The correct answer is option B. The broker must supervise licensed activity performed through the brokerage. A broker is responsible for the brokerage operation and for ensuring affiliated licensees follow applicable law and office procedures. Choice A is wrong because salespersons act under broker supervision. Choice C is wrong because broker supervision covers brokerage activity generally. And choice D is wrong because delegation does not remove the broker's responsibility. Question 10. When reviewing closing papers, a buyer gives earnest money to a listing broker in a purchase transaction. Where should money belonging to others be placed? Option A. In a separate broker escrow or trust account maintained for funds of others. Option B. In the seller's account before acceptance. Option C. In the broker's personal checking account. Option D. In the salesperson's desk until closing. The correct answer is option A. In a separate broker escrow or trust account maintained for funds of others. Trust funds must be safeguarded separately from the broker's personal and operating funds. Choice B is wrong because the seller is not automatically entitled to the buyer's deposit before proper disbursement. Choice C is wrong because that would mix client funds with personal money. And choice D is wrong because a salesperson should promptly account for and deliver funds to the broker. Question 11. Before meeting a client in Camden, a deposit is received while negotiations are expected to continue beyond 5 business days. How should the licensee handle the money? Option A. Deliver it to the broker so it can be deposited into the trust account within the required time. Option B. Give it to the listing salesperson for safekeeping. Option C. Deposit it into the broker's operating account. Option D. Hold it uncashed until all negotiations are finished. The correct answer is option A. Deliver it to the broker so it can be deposited into the trust account within the required time. When negotiations continue beyond the short statutory window, funds of others must be promptly segregated into the broker's trust account. Choice B is wrong because salespersons do not maintain trust accounts for client deposits. Choice C is wrong because operating accounts are not trust accounts for money of others. And choice D is wrong because ongoing negotiations do not allow indefinite personal holding of the deposit. Question 12. During a transaction in Hoboken, a broker places client earnest money into the same account used to pay office rent. Which violation is most directly shown? Option A. Redlining. Option B. This cheat. Option C. Blockbusting. Option D. Commingling. The correct answer is option D. Commingling. Commingling occurs when money of others is mixed with the broker's own business or personal funds. Choice A is wrong because redlining involves discriminatory lending or service patterns by area. Choice B is wrong because this cheat is the government's power to take property when an owner dies without heirs. And choice C is wrong because blockbusting involves inducing panic selling based on protected class changes. Question 13. In a brokerage file review, a broker intentionally uses escrow funds to pay a personal credit card bill. Which violation best describes this conduct? Option A. Conversion. Option B. Novation. Option C. Variance. Option D. Accretion. The correct answer is option A. Conversion. Conversion is the wrongful taking or use of another person's money or property for one's own purpose. Choice B is wrong because novation replaces a party or obligation in a contract and is not misuse of funds. Choice C is wrong because a variance is zoning relief, not taking another person's money. And choice D is wrong because accretion is a gradual addition to land by natural forces. Question 14. For a duplex in Atlantic City, a broker is authorized to take a commission from trust funds after it is earned. What must the broker do to avoid commingling? Option A. Leave the commission in escrow as a savings reserve. Option B. Transfer all trust funds to the operating account. Option C. Withdraw the commission from the trust account within the required time after it becomes payable. Option D. Pay the commission directly to the salesperson from escrow. The correct answer is option C. Withdraw the commission from the trust account within the required time after it becomes payable. Once money becomes the broker's earned commission, it should not remain in the trust account as though it were still client money. Choice A is wrong because earned broker funds should not remain mixed with trust funds. Choice B is wrong because client funds cannot be moved improperly to a business account. And choice D is wrong because salesperson compensation should be handled through the brokerage's proper accounting process. Question 15. While preparing a listing package, a licensee has an ownership interest in property being sold through the brokerage. What disclosure is required? Option A. The licensee's interest should be disclosed to the purchaser in the contract of sale. Option B. Disclosure is needed only after closing. Option C. No disclosure is needed if the price is fair. Option D. Only the lender needs to know. The correct answer is option A. The licensee's interest should be disclosed to the purchaser in the contract of sale. A licensee acting as a principal or having an ownership interest must disclose that conflict so the other party can make an informed decision. Choice B is wrong because the buyer must know before being bound to the transaction. Choice C is wrong because fair price does not remove the conflict of interest. And choice D is wrong because the purchaser is the party affected by the licensee's ownership interest. Question 16. At a salesperson training session, a salesperson wants to advertise a property exclusively listed by another brokerage. Which condition must be satisfied first? Option A. The salesperson may advertise it if the price is public. Option B, consent from any buyer is enough. Option C, no consent is required for social media posts. Option D, prior written consent from the listing broker must be obtained. The correct answer is option D. Prior written consent from the listing broker must be obtained. Exclusive listings cannot be advertised by another brokerage without proper authorization from the listing broker. Choice A is wrong because public price information does not authorize another broker's advertising. Choice B is wrong because the listing broker controls the exclusive listing advertising permission. And choice C is wrong because online advertising is still advertising subject to the rules. Question 17. After receiving an offer in Asbury Park, a salesperson creates a social media ad for a listing. Which identification should appear in the advertisement? Option A, only the property address. Option B, the salesperson's licensed name and the regular business name of the broker through whom the salesperson is licensed. Option C, only a personal cell phone number. Option D, only the salesperson's nickname. The correct answer is option B, the salesperson's licensed name and the regular business name of the broker through whom the salesperson is licensed. New Jersey advertising rules require clear identification of the licensed person and the brokerage business name. Choice A is wrong because property information does not identify the brokerage authority. Choice C is wrong because contact information alone does not satisfy brokerage identification rules. And choice D is wrong because ads must identify the licensed individual and broker appropriately. Question 18. During an agency disclosure conversation, a salesperson's advertisement shows the salesperson name in huge type and the broker's name in small print. Which issue is raised? Option A, the ad is valid because the salesperson paid for it. Option B, the ad is invalid only if it contains a price. Option C, the ad is valid if the property sells quickly. Option D, the broker's regular business name must appear more prominently than the non-broker licensee's name. The correct answer is option D. The broker's regular business name must appear more prominently than the non-broker licensee's name. Advertising must make the brokerage relationship clear to the public rather than presenting a salesperson as the brokerage. Choice A is wrong because payment for an ad does not change the prominence rule. Choice B is wrong because the broker identification rule is not limited to price advertisements. And choice C is wrong because sales success does not cure an advertising violation. Question 19. In a compliance audit, an ad states that the brokerage is licensed by the New Jersey Real Estate Commission. What additional message is generally required? Option A, a statement that commissions are fixed by law. Option B, a notice that the salesperson is an attorney. Option C, a promise that the commission guarantees the property condition. Option D, a clear statement that licensure does not imply endorsement. The correct answer is option D, a clear statement that licensure does not imply endorsement. A reference to commission licensure cannot be presented as though the state endorses the licensee's services. Choice A is wrong because commission rates are not fixed and such a claim would be misleading. Choice B is wrong because attorney status is unrelated unless it is actually true and relevant. And choice C is wrong because the commission does not guarantee listed property quality. Question 20. When reviewing closing papers, an advertisement mentions the brokerage's commission rate. Which statement should also be included in New Jersey? Option A, all commissions are set by the Real Estate Commission. Option B, in New Jersey commissions are negotiable. Option C, only sellers may negotiate commission. Option D, commission is due even if no brokerage agreement exists. The correct answer is option B. In New Jersey commissions are negotiable. New Jersey requires transparency when commission rates or fees are advertised so consumers are not misled into believing rates are fixed. Choice A is wrong because commission rates are not government fixed. Choice C is wrong because compensation arrangements may involve different parties depending on the agreement. And choice D is wrong because compensation depends on the applicable agreement and law. Question 21. Before meeting a client in Paterson, a referral agent prepares marketing materials for the public. Which limitation should be made clear? Option A, the referral agent may supervise salespersons. Option B, services are limited to referring prospects to a broker. Option C, the referral agent may hold escrow deposits. Option D, the referral agent may negotiate contracts alone. The correct answer is option B. Services are limited to referring prospects to a broker. A referral license is limited and should not be presented as full brokerage representation. Choice A is wrong because supervision is a broker-level responsibility. Choice C is wrong because referral status does not authorize trust fund handling. And choice D is wrong because negotiation is licensed brokerage activity beyond referral-only status. Question 22. During a transaction in Trenton, an unlicensed assistant is asked to host an open house, answer price questions, and negotiate offers. Which task creates the greatest licensing problem? Option A, typing a broker-approved flyer. Option B, negotiating offers with buyers or sellers. Option C, scheduling a showing without giving advice. Option D, ordering office supplies. The correct answer is option B, negotiating offers with buyers or sellers. Negotiating real estate terms is licensed brokerage activity and cannot be performed by an unlicensed assistant. Choice A is wrong because pure clerical support can be permissible when properly supervised. Choice C is wrong because ministerial scheduling is different from negotiation. And choice D is wrong because clerical purchasing does not require a real estate license. Question 23. In a brokerage file review, a broker is deciding how long transaction files and escrow records should be kept. Which compliance principle is most important? Option A. Let each salesperson keep the only file copy. Option B. Destroy records immediately after commission is paid. Option C. Maintain required records so the commission can review brokerage activity and trust accounting. Option D. Keep only text messages but no contracts. The correct answer is option C. Maintain required records so the commission can review brokerage activity and trust accounting. Record-keeping supports supervision, audits, consumer protection, and proof of proper handling of funds and documents. Choice A is wrong because brokerage records must be under responsible brokerage control. Choice B is wrong because paid commission does not end record-keeping duties. And choice D is wrong because contracts and financial records are central brokerage documents. Question 24. For a duplex in Hoboken, a broker's trust ledger does not match the bank balance and no reconciliation is performed. Which area is most directly at risk? Option A, land measurement. Option B, escrow account bookkeeping compliance. Option C, zoning variance approval. Option D, appraisal licensing. The correct answer is option B, escrow account bookkeeping compliance. Trust account records must accurately track client funds so shortages, overages, and improper disbursements can be detected. Choice A is wrong because survey or measurement issues are unrelated to trust ledger accuracy. Choice C is wrong because local land use relief is not the same as broker trust accounting. And choice D is wrong because value opinions do not correct escrow bookkeeping failures. Question 25. While preparing a listing package, a consumer loses money because a licensee unlawfully converts funds in a brokerage transaction. Which New Jersey protection may be relevant? Option A, a zoning board escrow. Option B, private mortgage insurance. Option C, a homeowners association reserve. Option D, the real estate guarantee fund. The correct answer is option D, the real estate guarantee fund. The Real Estate Guarantee Fund provides a potential recovery source for certain losses caused by embezzlement, conversion, or unlawful obtaining of property in brokerage transactions. Choice A is wrong because zoning boards do not reimburse brokerage fraud losses. Choice B is wrong because PMI protects a lender against borrower default, not a consumer from licensee conversion. And choice C is wrong because association reserves are for community expenses, not brokerage misconduct claims. Question 26. At a salesperson training session, a developer markets out-of-state subdivision interests to New Jersey purchasers. Which New Jersey law is most likely relevant? Option A, the Equal Credit Opportunity Act only. Option B, the Farmland Assessment Act only. Option C, the New Jersey Real Estate Sales Full Disclosure Act. Option D, the Truth in Renting Act only. The correct answer is option C, the New Jersey Real Estate Sales Full Disclosure Act. The Real Estate Sales Full Disclosure Act regulates certain real estate offerings marketed in New Jersey, including interests located outside the state. Choice A is wrong because ECOA addresses credit discrimination, not registration of out-of-state offerings. Choice B is wrong because farmland assessment deals with property tax treatment, and choice D is wrong because that law concerns rental disclosures rather than marketing subdivided land interests. Question 27. After receiving an offer in Morristown, a landlord refuses to rent to an otherwise qualified applicant because the applicant uses a lawful housing voucher. Which New Jersey rule is implicated? Option A. The rule of capture. Option B. The rule against fixtures. Option C. The statute of frauds only. Option D. The New Jersey law against discrimination protection for lawful source of income or rent payment. The correct answer is option D. The New Jersey law against discrimination protection for lawful source of income or rent payment. New Jersey fair housing protections include lawful source of income or rent payment in housing transactions. Choice A is wrong because that doctrine concerns natural resources, not rental screening. Choice B is wrong because fixture law concerns personal versus real property, not discrimination. And choice C is wrong because contract writing rules do not authorize source of income discrimination. Question 28. During an agency disclosure conversation, an agent guides buyers away from a neighborhood because of the buyer's national origin. Which prohibited practice is this? Option A. Defeasance. Option B. Steering. Option C. Accession. Option D. Puffing. The correct answer is option B. Steering. Steering occurs when a housing professional directs or limits choices because of a protected characteristic. Choice A is wrong because defeasance is a mortgage clause, not fair housing misconduct. Choice C is wrong because accession concerns ownership of added property, not discriminatory guidance. And choice D is wrong because puffing is exaggerated opinion and does not describe directing buyers based on protected status. Question 29. In a compliance audit, a licensee tells homeowners that people of a certain protected class are moving nearby and they should sell quickly. Which violation is shown? Option A. Subordination. Option B. Blockbusting. Option C. Assemblage. Option D. Redemption. The correct answer is option B. Blockbusting. Blockbusting uses fear or prejudice to induce sales or listings and is prohibited under fair housing principles. Choice A is wrong because subordination changes lien priority and is not panic selling. Choice C is wrong because assemblage combines parcels and is not a fair housing violation. And choice D is wrong because redemption concerns reclaiming property after default or foreclosure in certain contexts. Question 30. When reviewing closing papers, a lender refuses to make loans in neighborhoods with high minority populations regardless of applicant qualifications. Which term best describes this conduct? Option A. Redlining. Option B. Prioration. Option C. Reconciliation. Option D. Hypothecation. The correct answer is option A. Redlining. Redlining is the discriminatory denial or restriction of credit or services based on neighborhood characteristics tied to protected classes. Choice B is wrong because prioration divides expenses at closing and does not describe lending discrimination. Choice C is wrong because reconciliation is an appraisal step, not discriminatory lending geography. And choice D is wrong because hypothecation pledges property as security while retaining possession. Question 31. Before meeting a client in Newark, a landlord refuses to rent to families with children unless the property qualifies for a lawful senior housing exception. Which protected category is involved? Option A. Accretion. Option B. Subrogation. Option C. Familial status. Option D. Tenancy in common. The correct answer is option C. Familial status. Familial status protects households with children from discriminatory housing treatment unless a narrow legal exception applies. Choice A is wrong because accretion concerns land created by natural deposits. Choice B is wrong because subrogation is an insurance concept, not discrimination law. And choice D is wrong because that is an ownership form, not a fair housing class. Question 32. During a transaction in Jersey City, a tenant with a disability requests permission to keep an assistance animal despite a no-pets policy. Which response is most consistent with fair housing principles? Option A. Evaluate the request as a reasonable accommodation rather than automatically denying it as a pet violation. Option B. Approve only if every tenant votes yes. Option C. Deny it because all animal requests are identical to pet ownership. Option D. Charge a higher security deposit solely because of the disability. The correct answer is option A. Evaluate the request as a reasonable accommodation rather than automatically denying it as a pet violation. A disability-related accommodation may require an exception to ordinary rules when it is reasonable and necessary. Choice B is wrong because fair housing rights are not subject to a popularity vote. Choice C is wrong because assistance animal requests can be disability accommodations. And choice D is wrong because differential charges based on disability can be discriminatory. Question 33. In a brokerage file review, a seller asks the listing agent not to disclose a known structural defect to buyers. Which duty is most important? Option A, wait until after closing to mention the defect. Option B, material facts and known defects should be disclosed as required by law and professional duties. Option C, disclose only to the appraiser and not to buyers. Option D, follow the seller's instruction because loyalty always overrides disclosure. The correct answer is option B. Material facts and known defects should be disclosed as required by law and professional duties. Licensees owe honesty and disclosure duties that prevent concealment of material property facts. Choice A is wrong because post-closing disclosure is too late for informed buyer decision-making. Choice C is wrong because buyers are directly affected by the property condition. And choice D is wrong because loyalty does not permit concealment of material facts. Question 34. For a duplex in Trenton, an agent representing a seller also wants to represent the buyer in the same transaction. What is generally required for disclosed dual agency? Option A, only the seller's verbal permission. Option B, informed consent from both parties after proper disclosure. Option C, a lender's approval instead of client consent. Option D, no consent because dual agency is always automatic. The correct answer is option B. Informed consent from both parties after proper disclosure. Dual agency creates divided loyalty, so both parties must understand and consent to the relationship. Choice A is wrong because both clients are affected by dual representation. Choice C is wrong because lender approval does not replace the parties' informed agency consent. And choice D is wrong because dual agency is not automatic and requires disclosure and consent. Question 35. While preparing a listing package, two agents in the same brokerage are assigned separately to a buyer and a seller with appropriate consent. Which relationship is being used? Option A, novation. Option B, designated agency. Option C, redlining. Option D, tenancy et sufferance. The correct answer is option B, designated agency. Designated agency allows different licensees within one brokerage to represent different clients when the required disclosures and consents are handled. Choice A is wrong because novation replaces a party or obligation in a contract. Choice C is wrong because redlining is discriminatory lending or service practice. And choice D is wrong because that term describes occupancy after a lease ends, not brokerage representation. Question 36. At a salesperson training session, a broker helps both sides with paperwork but does not advocate as either party's fiduciary. Which relationship best fits that limited role? Option A, life tenant. Option B, mortgagee. Option C, universal agent with unlimited authority. Option D, transaction broker or facilitator. The correct answer is option D, transaction broker or facilitator. A transaction broker or facilitator assists with the transaction without becoming a full fiduciary advocate for one party. Choice A is wrong because a life tenant holds a property interest, not a brokerage relationship. Choice B is wrong because a mortgagee is the lender, not a neutral transaction facilitator. And choice C is wrong because a universal agent has broad authority that does not match a neutral facilitation role. Question 37. After receiving an offer in Princeton, a buyer asks whether a brokerage services agreement is needed before the licensee works with the buyer. Which answer best reflects current New Jersey consumer protection practice? Option A. A written brokerage services agreement is generally required when providing brokerage services to the buyer. Option B. A written agreement is never needed for buyers. Option C. Only sellers can have brokerage agreements. Option D. An oral handshake is always enough. The correct answer is option A. A written brokerage services agreement is generally required when providing brokerage services to the buyer. Written brokerage agreements improve transparency about services, representation, and compensation before the licensee works with a buyer. Choice B is wrong because current practice requires written agreements in buyer service situations. Choice C is wrong because buyers may also enter brokerage service agreements. and choice D is wrong because consumer protection rules emphasize written disclosure and agreement. Question 38. During an agency disclosure conversation, a licensee owes obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care to a client. Which concept is being tested? Option A, substitution. Option B, fiduciary duties. Option C, police power. Option D, this cheat. The correct answer is option B, fiduciary duties. Fiduciary duties define the high level of care and loyalty an agent owes to a client. Choice A is wrong because substitution is not the standard term for client fiduciary obligations. Choice C is wrong because police power is government regulation for public welfare. And choice D is wrong because this cheat is a government right involving ownerless property. Question 39. In a compliance audit, a licensee is working with a customer rather than a client. Which duty still applies? Option A, honesty and fair dealing with disclosure of known material facts. Option B, authority to sign contracts for the customer. Option C, undivided loyalty as a fiduciary client. Option D, permission to misstate property condition. The correct answer is option A, honesty and fair dealing with disclosure of known material facts. Even without a client fiduciary relationship, licensees must deal honestly and avoid concealing material information. Choice B is wrong because a licensee needs proper legal authority to sign for another person. Choice C is wrong because customers are not owed the full fiduciary loyalty owed to clients. And choice D is wrong because customer status does not allow misrepresentation. Question 40. When reviewing closing papers, a buyer submits an offer and the seller responds by changing the price and closing date. What is the seller's response? Option A, an appraisal report. Option B, a deed restriction. Option C, a counteroffer that rejects the original offer and proposes new terms. Option D, an acceptance of the original offer. The correct answer is option C, a counteroffer that rejects the original offer and proposes new terms. A counteroffer changes proposed terms and usually terminates the offeree's power to accept the original offer. Choice A is wrong because an appraisal estimates value and does not form contract terms. Choice B is wrong because a deed restriction limits property use and is not an offer response. And choice D is wrong because changing material terms prevents the response from being an acceptance. Question 41. Before meeting a client in Asbury Park, a valid real estate purchase contract is being reviewed. Which element is essential? Option A, an MLS number without parties or price. Option B, mutual assent, competent parties, lawful purpose, consideration, and sufficiently definite terms. Option C, a notarized deed before any agreement. Option D, only a handshake and a property photo. The correct answer is option B, mutual assent, competent parties, lawful purpose, consideration, and sufficiently definite terms. A valid contract requires agreement and legally sufficient elements, not just informal interest in a property. Choice A is wrong because an MLS reference alone does not establish contract obligations. Choice C is wrong because a deed transfers title and is separate from forming a purchase contract. And choice D is wrong because real estate contracts generally require more definite and documented terms. Question 42. During a transaction in Montclair, an offer states that acceptance must be communicated by 5 p.m. Friday. When does acceptance generally become effective? Option A, when the acceptance is properly communicated according to the offer's terms. Option B, when the seller starts thinking about the offer. Option C, when the buyer privately decides to accept. Option D, only after the deed is recorded. The correct answer is option A, when the acceptance is properly communicated according to the offer's terms. Contract formation generally requires objective acceptance communicated in the manner required by the offer. Choice B is wrong because consideration of an offer is not acceptance. Choice C is wrong because private intent does not notify the offerer. And choice D is wrong because recording relates to title notice, not contract acceptance. Question 43. In a brokerage file review, an agreement for the sale of real estate is made orally with no sufficient writing. Which doctrine is most likely involved? Option A, rule against perpetuities. Option B, statute of frauds. Option C, principle of substitution. Option D, doctrine of emblements. The correct answer is option B, statute of frauds. The statute of frauds generally requires real estate sale contracts to be in writing to be enforceable. Choice A is wrong because that doctrine concerns remote future interests, not the writing requirement for sales contracts. Choice C is wrong because substitution is an appraisal principle, not a contract writing requirement. And choice D is wrong because emblements concern crops grown by a tenant. Question 44. For a duplex in Jersey City, a purchase agreement says the buyer may cancel if financing is not approved by a stated date. What is this clause? Option A, a contingency. Option B, a deed covenant of season. Option C, a quitclaim deed. Option D, a tax assessment appeal. The correct answer is option A, a contingency. A contingency makes performance or continued obligation depend on a stated event or condition. Choice B is wrong because that deed covenant concerns ownership title, not a condition in a purchase agreement. Choice C is wrong because a quitclaim deed transfers whatever interest the grantor has. And choice D is wrong because an assessment appeal challenges value for taxation. Question 45. While preparing a listing package, a contract states that deadlines are strict and late performance may be a breach. Which phrase expresses that idea? Option A, quiet enjoyment. Option B, highest and best use. Option C, time is of the essence. Option D, caveat emptor. The correct answer is option C, time is of the essence. The phrase time is of the essence makes timely performance a material contract requirement. Choice A is wrong because quiet enjoyment protects possession from interference, not deadline strictness. Choice B is wrong because that valuation concept concerns the most profitable legal use. And choice D is wrong because that phrase means buyer beware and does not make deadlines strict. Question 46. At a salesperson training session, a seller breaches a valid purchase contract and the buyer wants the court to require transfer of the unique property. Which remedy is the buyer seeking? Option A, specific performance. Option B, amortization. Option C, subletting. Option D, assemblage. The correct answer is option A, specific performance. Specific performance asks a court to enforce the exact contractual promise, often because real estate is considered unique. Choice B is wrong because amortization is loan repayment over time. Choice C is wrong because subletting transfers a tenant's possession interest to another occupant. And choice D is wrong because assemblage combines parcels for development. Question 47. After receiving an offer in Camden, a seller grants a buyer the exclusive right to purchase property within 60 days while the seller must keep the offer open. What agreement is this? Option A, a gross lease. Option B, a release deed. Option C, a blanket mortgage. Option D, an option contract. The correct answer is option D, an option contract. An option gives the holder the right, but not the obligation, to buy or lease under stated terms during the option period. Choice A is wrong because a gross lease concerns rent and operating expenses. Choice B is wrong because a release deed removes or gives up a claim or interest. And choice C is wrong because a blanket mortgage covers more than one parcel as security. Question 48. During an agency disclosure conversation, a kitchen chandelier is physically attached, intended to stay, and adapted to the room. How is it most likely classified? Option A, embellishment. Option B, fixture. Option C, personal property that always remains with the seller. Option D, trade fixture of a tenant. The correct answer is option B, fixture. A fixture is personal property that has become part of the real estate through attachment, adaptation, and intent. Choice A is wrong because emblements are cultivated crops. Choice C is wrong because attached items intended to stay often become real property. And choice D is wrong because a residential seller's chandelier is not usually a tenant business fixture. Question 49. In a compliance audit, two unrelated buyers own unequal shares of property and each share can pass by will. Which ownership form is most likely? Option A, leasehold estate only. Option B, severalty. Option C, joint tenancy with automatic survivorship. Option D, tenancy in common. The correct answer is option D, tenancy in common. Tenants in common may own unequal shares and each owner's interest can pass through that owner's estate. Choice A is wrong because a leasehold is a possessory right under a lease, not co-ownership of title. Choice B is wrong because severalty means ownership by one person or entity alone. and choice C is wrong because joint tenancy includes survivorship and usually equal ownership interests. Question 50. When reviewing closing papers, two owners want the surviving owner to automatically receive the deceased owner's interest. Which ownership feature is needed? Option A, right of survivorship. Option B, severalty. Option C, divulsion. Option D, deficiency judgment. The correct answer is option A, right of survivorship. Right of survivorship causes a deceased co-owner's interest to pass automatically to the surviving co-owner or co-owners. Choice B is wrong because severalty involves one owner and no co-owner survivorship. Choice C is wrong because avulsion is a sudden natural change in land. And choice D is wrong because a deficiency judgment follows insufficient foreclosure sale proceeds. Question 51. Before meeting a client in Morristown, a person receives possession and use of property for the duration of another person's life. Which estate is described? Option A, easement in gross. Option B, periodic tenancy. Option C, fee simple absolute. Option D, life estate. The correct answer is option D, life estate. A life estate lasts only for the lifetime of a named person and then ends or passes to the future interest holder. Choice A is wrong because an easement is a use right, not a possessory estate for life. Choice B is wrong because periodic tenancy is a leasehold that renews for successive periods. And choice C is wrong because fee simple absolute is the broadest ownership estate and is not limited by a measuring life. Question 52. During a transaction in Edison, a buyer purchases an individual unit and an undivided interest in common areas. Which form of ownership is most likely involved? Option A, cooperative ownership only. Option B, condominium ownership. Option C, easement by necessity. Option D, license only. The correct answer is option B, condominium ownership. Condominium owners hold title to their units plus a shared interest in common elements. Choice A is wrong because a cooperative usually involves shares in a corporation and a proprietary lease. Choice C is wrong because that easement provides access and does not create unit ownership. And choice D is wrong because a license is permission rather than ownership of a unit. Question 53. In a brokerage file review, a driveway easement benefits a neighboring parcel and transfers with that parcel. Which type of easement is this? Option A, easement appurtenant. Option B, encroachment. Option C, a mechanic's lien. Option D, easement in gross for a person only. The correct answer is option A, easement appurtenant. An easement appurtenant benefits land and generally runs with the benefited parcel when ownership changes. Choice B is wrong because an encroachment is an unauthorized physical intrusion. Choice C is wrong because a mechanic's lien secures payment for labor or materials. And choice D is wrong because an easement in gross benefits a person or entity rather than a parcel. Question 54. For a duplex in Montclair, a neighbor's garage extends 2 feet onto another owner's land. Which title issue is most likely present? Option A, novation. Option B, eminent domain. Option C, functional obsolescence. Option D, encroachment. The correct answer is option D, encroachment. An encroachment occurs when an improvement extends onto another's property without proper right. Choice A is wrong because novation substitutes a new party or obligation in a contract. Choice B is wrong because eminent domain is a government taking for public use. And choice C is wrong because functional obsolescence is a valuation issue related to design or utility. Question 55. While preparing a listing package, a contractor records a claim against property because the owner did not pay for improvements. Which encumbrance is most likely? Option A, mechanic's lien. Option B, license. Option C, literal right. Option D, variance. The correct answer is option A, mechanic's lien. A mechanic's lien can secure payment for labor or materials furnished to improve real property. Choice B is wrong because a license is permission to use property and does not secure payment. Choice C is wrong because literal rights relate to property bordering large bodies of water. And choice D is wrong because a variance is zoning permission to deviate from rules. Question 56. At a salesperson training session, a legal description begins at a point of beginning and follows directions and distances around the parcel. Which description method is being used? Option A, street address only. Option B, meets and bounds. Option C, datum reference only. Option D, lot and block. The correct answer is option B, meets and bounds. Meets and bounds descriptions use boundary lines, angles, distances, and a point of beginning. Choice A is wrong because a street address is not the most reliable legal description. Choice C is wrong because a datum is an elevation reference, not a complete boundary description. And choice D is wrong because lot and block refers to recorded subdivision map identifiers. Question 57. After receiving an offer in Patterson, a deed identifies property as Lot 12, Block 8 on a recorded subdivision map. Which legal description method is this? Option A, meets and bounds. Option B, government rectangular survey only. Option C, informal address description. Option D, lot and block. The correct answer is option D, lot and block. Lot and block descriptions identify parcels by reference to a recorded plat or subdivision map. Choice A is wrong because meets and bounds relies on courses and distances from a point of beginning. Choice B is wrong because that system uses principal meridians, baselines, townships, and ranges. And choice C is wrong because a recorded lot and block is more formal than a street address. Question 58. During an agency disclosure conversation, a municipality adopts zoning rules to control land use for public welfare. Which government power is being exercised? Option A is cheat. Option B, eminent domain. Option C, taxation. Option D, police power. The correct answer is option D, police power. Zoning is a classic exercise of police power because it regulates land use to protect health, safety, and welfare. Choice A is wrong because this cheat applies when property has no lawful owner or heirs. Choice B is wrong because eminent domain involves taking property for public use with compensation. And choice C is wrong because taxation raises revenue rather than directly regulating land use patterns. Question 59. In a compliance audit, the government takes private land for a highway project and pays just compensation. Which power is being used? Option A, eminent domain. Option B, accretion. Option C, private restriction. Option D, this cheat. The correct answer is option A, eminent domain. Eminent domain allows government to take private property for public use when just compensation is paid. Choice B is wrong because accretion is land buildup from natural causes. Choice C is wrong because private restrictions are created by deeds or covenants, not government takings. And choice D is wrong because this cheat deals with ownerless property or lack of heirs. Question 60. When reviewing closing papers, a property owner dies intestate with no heirs, and the property passes to the state. Which government right applies? Option A is cheat. Option B, condemnation. Option C, special assessment. Option D, police power. The correct answer is option A, is cheat. Is cheat prevents property from remaining ownerless when there are no lawful heirs. Choice B is wrong because condemnation is the legal process used in eminent domain. Choice C is wrong because a special assessment pays for a public improvement benefiting property. And choice D is wrong because police power regulates property use rather than transferring ownerless property. Question 61. Before meeting a client in Princeton, a subdivision deed says homes may not be used for commercial auto repair. What type of private control is this? Option A, a title abstract. Option B, a deficiency judgment. Option C, a deed restriction or covenant. Option D, a tax prioration. The correct answer is option C, a deed restriction or covenant. Private deed restrictions and covenants limit how property may be used even when public zoning would otherwise permit the use. Choice A is wrong because a title abstract summarizes recorded title history. Choice B is wrong because a deficiency judgment seeks unpaid debt after foreclosure sale proceeds are insufficient. And choice D is wrong because tax prioration allocates taxes at closing. Question 62. During a transaction in Atlantic City, a buyer considers land in a mapped flood area and near regulated wetlands. Which issue should trigger extra investigation? Option A, automatic exemption from all zoning. Option B, immediate title transfer without due diligence. Option C, land use and environmental restrictions that may limit development. Option D, guaranteed mortgage approval. The correct answer is option C, land use and environmental restrictions that may limit development. Flood zones and wetlands can affect insurance, development approvals, and lawful use of property. Choice A is wrong because environmentally sensitive land is often more regulated, not exempt. Choice B is wrong because special land conditions usually require more review, not less, and choice D is wrong because environmental concerns do not guarantee financing. Question 63. In a brokerage file review, a salesperson prepares a pricing opinion for a seller using recently sold comparable homes. What is the salesperson most likely preparing? Option A. A comparative market analysis. Option B. A deed of trust. Option C. A zoning ordinance. Option D. A certified appraisal. The correct answer is option A. A comparative market analysis. A comparative market analysis helps estimate a likely listing or sale price using market data but is not a licensed appraisal. Choice B is wrong because a deed of trust is a financing security instrument in some states. Choice C is wrong because a zoning ordinance is a government land use rule. And choice D is wrong because a CMA is not the same as a formal appraisal by a certified appraiser. Question 64. For a duplex in Edison, an appraiser estimates value by comparing the subject property to recently sold similar properties. Which approach is being used? Option A, income approach. Option B, sales comparison approach. Option C, cost approach. Option D, subdivision approach. The correct answer is option B, sales comparison approach. The sales comparison approach is based on substitution and uses comparable sales adjusted for differences. Choice A is wrong because the income approach converts income into value. Choice C is wrong because the cost approach estimates land value plus replacement or reproduction cost less depreciation. And choice D is wrong because that is a specialized development analysis, not the standard comparable sales method. Question 65. While preparing a listing package, an investor's apartment building is valued by converting net operating income into value. Which appraisal approach is being used? Option A, assessed value approach. Option B, cost approach. Option C, income approach. Option D, sales comparison only. The correct answer is option C, income approach. The income approach is commonly used for income-producing properties because investors buy the expected income stream. Choice A is wrong because tax assessments are not one of the three primary appraisal approaches. Choice B is wrong because cost analysis focuses on land and improvements rather than capitalized income. And choice D is wrong because sales comparison uses adjusted sale prices of comparable properties. Question 66. At a salesperson training session, a buyer chooses a loan insured by the Federal Housing Administration. Which statement best describes the loan? Option A. The loan requires no underwriting. Option B. The loan is made directly by the seller. Option C. The loan is guaranteed by the Department of Veterans Affairs. Option D. The loan is made by an approved lender and insured by FHA. The correct answer is option D. The loan is made by an approved lender and insured by FHA. FHA insurance protects the lender and allows qualified borrowers to use FHA program terms. Choice A is wrong because FHA loans still involve borrower and property underwriting. Choice B is wrong because seller financing is separate from FHA-insured lending. And choice C is wrong because VA guarantees eligible veteran loans rather than FHA loans. Question 67. After receiving an offer in Newark, a buyer signs a promise to repay the loan and also gives the lender a security interest in the property. Which documents are involved? Option A, listing agreement and agency disclosure only. Option B, deed and bill of sale only. Option C, survey and appraisal only. Option D, promissory note and mortgage. The correct answer is option D, promissory note and mortgage. The note is the borrower's debt promise, while the mortgage secures that debt with real property. Choice A is wrong because brokerage documents do not create the borrower's debt and security pledge. Choice B is wrong because a deed transfers title and a bill of sale transfers personal property. And choice C is wrong because surveys and appraisals provide information but do not create the loan obligation. Question 68. During an agency disclosure conversation, a lender requires private mortgage insurance because the borrower has a small down payment. Which purpose does PMI serve? Option A. It protects the lender if the borrower defaults on a high LTV conventional loan. Option B. It replaces the need for a promissory note. Option C. It protects the borrower from losing equity if prices decline. Option D. It guarantees that property taxes will not rise. The correct answer is option A. It protects the lender if the borrower defaults on a high LTV conventional loan. Private mortgage insurance is commonly required when lender risk is higher because the borrower has limited equity. Choice B is wrong because the borrower still signs a debt obligation. Choice C is wrong because PMI is lender protection, not market loss insurance for the borrower. And choice D is wrong because PMI has no effect on tax assessments. Question 69. In a compliance audit, a lender provides the loan estimate and closing disclosure under Federal Integrated Disclosure Rules. Which topic is involved? Option A. A broker price opinion only. Option B. TRID disclosure requirements. Option C. A zoning variance. Option D. A deed restriction. The correct answer is option B. TRID disclosure requirements. TRID rules integrate federal mortgage disclosures so borrowers receive clearer information about loan terms and closing costs. Choice A is wrong because pricing opinions do not replace loan disclosure rules. Choice C is wrong because a variance is land use permission from a local authority. And choice D is wrong because deed restrictions are private limits on property use. Question 70. When reviewing closing papers, a creditor refuses to consider an applicant's income because of the applicant's marital status. Which federal credit law is implicated? Option A. Municipal Land Use Law. Option B. Equal Credit Opportunity Act. Option C. Real Estate Settlement Procedures Act. Option D. Truth in Renting Act. The correct answer is option B. Equal Credit Opportunity Act. The Equal Credit Opportunity Act prohibits discrimination in credit transactions based on protected factors. Choice A is wrong because that law concerns local land use planning and approvals. Choice C is wrong because RESPA focuses on settlement practices and certain referral issues, not all credit discrimination. And choice D is wrong because that is a New Jersey landlord-tenant disclosure law. Question 71. Before meeting a client in Camden, a title search finds an unreleased old mortgage that may affect ownership. What is this issue commonly called? Option A. A cloud on title. Option B. A functional obsolescence. Option C. A variance. Option D. A gross lease. The correct answer is option A. A cloud on title. A cloud on title is a claim, defect, or unresolved matter that may impair marketable title. Choice B is wrong because functional obsolescence is a loss in value from outdated design or utility. Choice C is wrong because a variance is zoning relief and does not clear title. And choice D is wrong because a gross lease concerns rent payment structure. Question 72. During a transaction in Hoboken, a buyer wants assurance against certain hidden title defects after closing. Which product is designed for that purpose? Option A. A home warranty only. Option B. Private mortgage insurance. Option C. Hazard insurance only. Option D. Title insurance. The correct answer is option D. Title insurance. Title insurance protects against covered title defects that may not be discovered before closing. Choice A is wrong because a home warranty addresses covered systems or construction issues, not ownership title. Choice B is wrong because PMI protects the lender from borrower default. And choice C is wrong because hazard insurance covers physical damage risks, not title defects. Question 73. In a brokerage file review, a deed is signed, delivered, and accepted by the grantee. When does title generally pass? Option A. Upon valid delivery and acceptance of the deed. Option B. Only when the property is advertised online. Option C. Only when the listing agreement is signed. Option D. Only when the buyer first tours the property. The correct answer is option A. Upon valid delivery and acceptance of the deed. A deed transfers title when it is properly executed, delivered, and accepted. Choice B is wrong because advertising does not convey ownership. Choice C is wrong because a listing agreement authorizes brokerage services and does not transfer title. And choice D is wrong because a showing creates no title transfer. Question 74. For a duplex in Atlantic City, a deed contains no warranties and transfers only whatever interest the grantor may have. Which deed is most likely? Option A. General warranty deed. Option B. Installment land contract. Option C. Quitclaim deed. Option D. Bargain and sale deed with covenants. The correct answer is option C. Quitclaim deed. A quitclaim deed conveys any interest the grantor has without promising that title is valid. Choice A is wrong because a general warranty deed provides broad title warranties. Choice B is wrong because that is a financing arrangement, not a deed type, and choice D is wrong because that deed contains limited assurances beyond a quitclaim. Question 75. While preparing a listing package, a buyer records a deed promptly after closing. What is the main purpose of recording? Option A. To make an invalid deed automatically valid. Option B. To give public notice of the buyer's interest. Option C. To create the buyer's loan obligation. Option D. To set the zoning classification. The correct answer is option B. To give public notice of the buyer's interest. Recording protects the buyer by making the ownership claim part of the public record. Choice A is wrong because recording does not cure all defects in execution or delivery. Choice C is wrong because the note creates the debt obligation. And choice D is wrong because zoning is controlled by municipal regulation. Question 76. At a salesperson training session, a lender forecloses because the borrower defaults and the sale proceeds do not fully cover the debt. Which term may describe the remaining unpaid amount? Option A, equity. Option B, estoppel certificate. Option C, accession. Option D, deficiency. The correct answer is option D, deficiency. A deficiency is the remaining debt when foreclosure sale proceeds are not enough to satisfy the obligation. Choice A is wrong because equity is the owner's value above liens, not unpaid debt after sale. Choice B is wrong because an estoppel certificate confirms facts such as lease status. And choice C is wrong because accession concerns property added by natural or artificial means. Question 77. After receiving an offer in Asbury Park, a seller owes more on the mortgage than the property is expected to sell for and asks the lender to approve a reduced payoff. What transaction is being discussed? Option A, short sale. Option B, tax assessment appeal. Option C, adverse possession. Option D, installment sale with no lender involvement. The correct answer is option A, short sale. A short sale requires lender cooperation because the sale price will not fully satisfy the mortgage debt. Choice B is wrong because an assessment appeal challenges taxable value, not lender payoff. Choice C is wrong because adverse possession is acquiring title through possession under strict requirements. And choice D is wrong because a short sale specifically involves lender approval of less than the full payoff. Question 78. During an agency disclosure conversation, a tenant pays one fixed rent amount and the landlord pays most operating expenses. Which lease type is most likely? Option A, net lease. Option B, ground lease. Option C, percentage lease. Option D, a gross lease. The correct answer is option D, gross lease. In a gross lease, the tenant generally pays a fixed rent while the landlord covers specified property expenses. Choice A is wrong because a net lease shifts some or all property expenses to the tenant. Choice B is wrong because a ground lease usually leases land for long-term development. And choice C is wrong because a percentage lease includes rent based partly on business sales. Question 79. In a compliance audit, a retail tenant pays base rent plus a share of gross sales. Which lease type is this? Option A, life estate. Option B, gross lease. Option C, percentage lease. Option D, graduated deed. The correct answer is option C, percentage lease. Percentage leases are common in retail settings because rent is tied partly to the tenant's business performance. Choice A is wrong because a life estate is an ownership estate rather than a lease. Choice B is wrong because a gross lease uses a fixed rent structure without a sales percentage as the defining feature. And choice D is wrong because that is not a standard lease type. Question 80. When reviewing closing papers, a property manager holds rent deposits and security funds for an owner. Which duty is central to that role? Option A, ignoring owner instructions whenever convenient. Option B, guaranteeing future property appreciation. Option C, using trust funds to pay personal bills. Option D, fiduciary accounting and safeguarding of funds. The correct answer is option D, fiduciary accounting and safeguarding of funds. Property managers handle other people's property and money, so fiduciary care and accurate accounting are essential. Choice A is wrong because a manager owes duties to the owner under the management agreement. Choice B is wrong because a manager cannot guarantee market value increases. And choice C is wrong because personal use of client funds is conversion. Question 81. Before meeting a client in Patterson, a leasing office refuses to provide a reasonable accessibility accommodation for a qualified applicant with a disability. Which compliance area is implicated? Option A. Only fixture classification. Option B. Fair housing and aid-related property management duties. Option C. Only tax preparation. Option D. Only capitalization rate analysis. The correct answer is option B. Fair housing and aid-related property management duties. Property management must comply with fair housing and accessibility requirements when dealing with applicants and tenants. Choice A is wrong because fixture law does not excuse discriminatory leasing practices. Choice C is wrong because tax allocation does not address disability accommodation. And choice D is wrong because income valuation does not resolve accommodation duties. Question 82. During a transaction in Trenton, a seller says there is no need to disclose lead-based paint information for a home built in 1965. Which response is best? Option A. Lead-based paint disclosures are required for many residential properties built before 1978. Option B. Lead disclosure applies only to newly constructed homes. Option C. Lead disclosure is optional if the seller dislikes paperwork. Option D. Lead disclosure applies only to vacant land. The correct answer is option A. Lead-based paint disclosures are required for many residential properties built before 1978. Federal lead-based paint rules are a key property disclosure topic for older residential housing. Choice B is wrong because newer construction is generally less likely to trigger the federal pre-1978 rule. Choice C is wrong because disclosure duties are not waived by convenience. And choice D is wrong because the rule concerns certain residential dwellings, not vacant parcels. Question 83. In a brokerage file review, a buyer asks whether marketable title and insurable title mean exactly the same thing. Which answer is best? Option A. A marketable title refers only to zoning. Option B. They always mean no title issues exist anywhere. Option C. They are related but not identical because a title company may insure some risks that still require review. Option D. Insurable title means the deed was never recorded. The correct answer is option C. They are related but not identical because a title company may insure some risks that still require review. Marketable title focuses on reasonable freedom from defects, while insurable title focuses on what a title insurer is willing to insure. Choice A is wrong because marketability concerns ownership title, not just land use. Choice B is wrong because even insured titles can have exceptions or exclusions. And choice D is wrong because insurability does not depend on avoiding recording. Question 84. For a duplex in Hoboken, a listing agreement gives one broker the exclusive right to earn a commission if the property sells during the listing period. Which listing type is described? Option A. Option contract. Option B. Net listing. Option C. Open listing only. Option D. The exclusive right to sell listing. The correct answer is option D. Exclusive right to sell listing. An exclusive right to sell listing gives the listing broker the strongest commission protection during the listing term. Choice A is wrong because an option gives a right to buy rather than appointing a listing broker. Choice B is wrong because a net listing pays the broker amounts above a seller's desired net and raises legal and ethical concerns. And choice C is wrong because an open listing allows multiple brokers and only the procuring broker earns commission. Question 85. While preparing a listing package, a buyer asks whether all commission rates are fixed by New Jersey law. Which answer is best? Option A. The commission sets a mandatory statewide commission. Option B. Commission rates are negotiable between the parties and the brokerage. Option C. Only listing brokers may negotiate commissions and buyers never may. Option D. Commission is illegal in all residential sales. The correct answer is option B. Commission rates are negotiable between the parties and the brokerage. Antitrust and consumer protection principles require avoiding claims that commissions are fixed or uniform. Choice A is wrong because state law does not set a mandatory brokerage commission rate. Choice C is wrong because compensation terms depend on the applicable agreement. And choice D is wrong because licensed brokerage compensation is permitted when properly earned and disclosed. Question 86. At a salesperson training session, several brokers agree not to charge below a certain commission rate. Which legal concern is most direct? Option A. Adverse possession. Option B. Easement by necessity. Option C, price fixing under antitrust law. Option D, prioration. The correct answer is option C, price fixing under antitrust law. Competitors may not agree to set commission rates because such agreements restrain competition. Choice A is wrong because adverse possession concerns acquiring title through possession. Choice B is wrong because that easement provides access to landlocked property. And choice D is wrong because prioration allocates expenses at closing. Question 87. After receiving an offer in Morristown, brokers divide a city and agree that each will work only in assigned neighborhoods. Which antitrust violation is suggested? Option A, tie-in survey. Option B, substitution principle. Option C, specific performance. Option D, a market allocation. The correct answer is option D, market allocation. Market allocation occurs when competitors divide customers or territories instead of competing freely. Choice A is wrong because that is not the standard term for dividing markets. Choice B is wrong because substitution is a valuation concept. And choice C is wrong because specific performance is a contract remedy. Question 88. During an agency disclosure conversation, a buyer asks why due diligence matters before buying a property near the Pinelands. Which New Jersey topic is most relevant? Option A, only fixture ownership. Option B, Pinelands Protection Act and land use restrictions. Option C, only private mortgage insurance. Option D, only commission splitting. The correct answer is option B, Pinelands Protection Act and land use restrictions. Special New Jersey land use laws can affect development rights and permissible uses in protected areas. Choice A is wrong because fixture law does not control regional environmental regulation. Choice C is wrong because PMI does not address protected land use areas. And choice D is wrong because compensation issues do not decide environmental land use limits. Question 89. In a compliance audit, a landlord must provide certain required rental information to tenants under New Jersey law. Which topic is most relevant? Option A, Real Estate Guarantee Fund. Option B, Eminent Domain. Option C, Truth in Renting Act. Option D, General Warranty Deed. The correct answer is option C, Truth in Renting Act. The Truth in Renting Act is a New Jersey landlord-tenant disclosure topic included in state law review. Choice A is wrong because the fund addresses certain losses from licensee misconduct. Choice B is wrong because eminent domain is a government taking, not tenant disclosure. And choice D is wrong because deeds transfer title and do not provide rental notices. Question 90. When reviewing closing papers, a buyer asks whether freshwater wetlands on a parcel can affect construction plans. Which New Jersey topic is most relevant? Option A, net lease. Option B, discount points. Option C, joint tenancy. Option D, a Freshwater Wetlands Protection Act. The correct answer is option D, Freshwater Wetlands Protection Act. Freshwater wetlands regulation can restrict development and require permits or approvals before construction. Choice A is wrong because net leases allocate property expenses between landlord and tenant. Choice B is wrong because discount points are prepaid loan interest charges. And choice C is wrong because joint tenancy is a form of co-ownership. Question 91. Before meeting a client in Newark, a buyer purchases a property for $455,000 and obtains a mortgage loan of $341,250. What is the loan-to-value ratio? Option A, 85%. Option B, 75%. Option C, 25%. Option D, 67.6%. The correct answer is option B, 75%. Loan-to-value is the loan amount divided by the purchase price, so $341,250 divided by $455,000 equals 75%. Choice A is wrong because that overstates the ratio by adding an unrelated percentage. Choice C is wrong because that calculates the down payment percentage rather than the loan-to-value ratio. And choice D is wrong because that divides by the wrong property value. Question 92. During a transaction in Jersey City, a borrower pays 3 discount points on a $330,000 loan. How much do the points cost? Option A, $99,000. Option B, $13,200. Option C, $9,900. Option D, $110,000. The correct answer is option C, $9,900. 1 discount point equals 1% of the loan amount. So 3 points equals 3% of $330,000, or $9,900. Choice A is wrong because that treats each point as 10% instead of 1%. Choice B is wrong because that uses the wrong number of discount points. And choice D is wrong because that divides by the point number instead of multiplying by the point percentage. Question 93. In a brokerage file review, a listing sells for $675,000 with a total commission rate of 5.5%. What is the total commission? Option A, $37,125. Option B, $43,875. Option C, $637,875. Option D, $3,713. The correct answer is option A, $37,125. Total commission is sale price multiplied by the commission rate. So $675,000 times 5.5% equals $37,125. Choice B is wrong because that uses a commission rate 1 percentage point too high. Choice C is wrong because that calculates approximate seller proceeds before other costs rather than commission. And choice D is wrong because that moves the decimal point incorrectly. Question 94. For a duplex in Trenton, a property sells for $680,000. The total commission is 6%, and a salesperson receives 50% of the brokerage's commission. What is the salesperson's share if this is the only split applied? Option A, $20,400. Option B, $40,800. Option C, $340,000. Option D, $20,400. The correct answer is option A, $20,400. First calculate the total commission of $40,800, then multiply by the 50% split to get $20,400. Choice B is wrong because that gives the full commission before the split. Choice C is wrong because that applies the split percentage to the sale price instead of the commission. And choice D is wrong because that gives the other side of the split. Question 95. While preparing a listing package, annual property taxes are $9,900 and the seller owes taxes for 165 days using a 365-day proration method. What is the seller's tax proration? Option A, $136,125. Option B, $4,475.34. Option C, $5,424.66. Option D, $4,537.50. The correct answer is option B, $4,475.34. Daily taxes are $9,900 divided by 365, and multiplying by 165 days gives $4,475.34. Choice A is wrong because that treats days as months. Choice C is wrong because that gives the remaining annual taxes instead of the prorated amount. And choice D is wrong because that uses a 360-day year rather than the stated 365-day method. Question 96. At a salesperson training session, a buyer purchases a home for $650,000 and makes a 20% down payment. How much is the down payment? Option A, $10,833. Option B, $520,000. Option C, $130,000. Option D, $162,500. The correct answer is option C, $130,000. The down payment equals the purchase price multiplied by 20%, which is $130,000. Choice A is wrong because that divides the down payment as though it were a monthly payment. Choice B is wrong because that calculates the amount financed rather than the down payment. And choice D is wrong because that uses the wrong down payment percentage. Question 97. After receiving an offer in Princeton, a seller's sale price is $740,000, mortgage payoff is $400,000, and closing costs are $27,000. What are the seller's estimated net proceeds before other adjustments? Option A, $313,000. Option B, $713,000. Option C, $427,000. Option D, $340,000. The correct answer is option A, $313,000. Seller net is sale price minus the mortgage payoff and closing costs, so $740,000 to $400,000, $27,000 equals $313,000. Choice B is wrong because that omits the mortgage payoff. Choice C is wrong because that adds deductions instead of subtracting them from the sale price. And choice D is wrong because that omits closing costs. Question 98. During an agency disclosure conversation, an income property has net operating income of $105,000 and a value of $1,200,000. What is the capitalization rate? Option A, 11.43%. Option B, 87.5%. Option C, 10.75%. Option D, 8.75%. The correct answer is option D, 8.75%. Capitalization rate is net operating income divided by value, so $105,000 divided by $1,200,000 equals 8.75%. Choice A is wrong because that divides value by income and does not produce a capitalization rate. Choice B is wrong because that shifts the decimal place incorrectly, and choice C is wrong because that adds an unrelated percentage to the calculation. Question 99. In a compliance audit, a monthly mortgage payment includes $2,080 for principal and interest, $700 for taxes, and $225 for insurance. What is the pity payment? Option A, $2,305. Option B, $3,005. Option C, $2,780. Option D, $925. The correct answer is option B, $3,005. Pity includes principal, interest, taxes, and insurance, so adding $2,080, $700, and $225 gives $3,005. Choice A is wrong because that omits taxes. Choice C is wrong because that omits insurance. And choice D is wrong because that omits principal and interest. Question 100. When reviewing closing papers, a rectangular parcel measures 165 feet by 116 feet. What is its area? Option A, 19,140 square feet. Option B, 0.44 square feet. Option C, 281 square feet. Option D, 562 square feet. The correct answer is option A, 19,140 square feet. Area is length multiplied by width, so 165 feet times 116 feet equals 19,140 square feet. Choice B is wrong because that converts to acres but labels the result incorrectly. Choice C is wrong because that adds dimensions rather than multiplying them. And choice D is wrong because that calculates perimeter instead of area.